Can you hear me? Okay, I don't have a PowerPoint. I'm a little too old to learn. I'm going to have to learn how to do PowerPoints one day, but I do have a prop. Um, I was very delighted to hear you refer to me as a rock star because my daughter, who's a student at NYU, was here, and it's great that you announced that. And then you said I was anal, and then I'm not so sure I wanted her to hear that. So, in any event,
Can I say one more thing which I forgot? Alan is the dean of the law financing, which is a parallel industry where funders put money into law firms to then bring cases. So he's now segueing into also commercial funding.
So I've been doing this for about 20 years. I got into this business actually by accident, and I have my own take on what this is about and what litigation funding is about. And I'm going to try to give you what I learned in 20 years in 8 minutes, and I apologize because I'm sure there's a lot of things I would have loved to say that I didn't say. First of all, we live in a wonderful country that for 225 years has grown and thrived because we have a capitalistic economic system that allows people to pursue economic ventures without hindrance, and we are blessed to have that today. And we've amassed more wealth than any country in the history of mankind because of that, among other things. Secondly, you cannot have an effective, well-performing economic capitalistic system unless there's a place where people can go when they have disputes to get those disputes resolved that is fair, that's orderly, and that ends up with the parties knowing where they stand at the end of the day. And in America, we have what we call the civil justice system. And that's why this whole thing exists. I don't refer to the kind of funding we're talking about as third-party funding, because I don't know who the second party is, but my view is you're either a party or you're not a party, and the party is the plaintiff and the defendant, and if you're coming in and putting money in, then you're a non-party funder, and that's really how I look at this universe. So here you are. So if you are a citizen and you have a claim and a dispute with somebody, we called it shows in action is what they called it in England, but essentially it's a property right that you have to go to court and pursue a claim. It costs an enormous amount of money today to have access to that civil justice system we have. It's a fact, okay? And I don't think anybody in this room could tell you that's not true. So here's my prop. You need to have this, okay? If you want to have access to the civil justice system, you need to have this, period. And I don't think there's any dispute about that, and I'd be happy to debate anybody who has a difference of opinion. Secondly, or thirdly, we have tremendous economic disparity in America, well, with all the wealth. And most people, I would say most people in America, could not afford to hire a lawyer and participate in the civil justice system because it's enormously expensive. And I'm talking, and we're involved in this world, you know, $25,000 a month in attorney's fees is not unusual. $100,000 in attorney's fees is not unusual. How many people in this room could start writing checks for $100,000 a month or $25,000 a month or want to? So if you want to have access, you want to give people access to the system, you have two choices. You have a system that's only for the wealthy, that can afford, that can dip in their pocket and afford to pay that, or you have some mechanism in our economic system where you provide funding, non-party funding, to that person seeking access. And those are the two options that we have. And I believe, and I think everybody in this room would agree, that we want to provide access to our civil justice system to people who cannot afford it, which is the vast majority of people. So what we have developed here in America is various mechanisms and historically various ways to provide the economic funding. We started with, I'm not going to talk much about the contingency fee because it's going to be discussed later, but it was in the middle 1800s in the United States at the beginning of the Industrial Revolution in America that we accepted the contingent fee as a means to fund a lawsuit. And what that means is I, as a lawyer, can offer my legal services to an individual or a company, whoever it may be, to have access to the system. But in addition to that, I am a non-party funder. I'm putting my money in to pay costs and my money in to keep my business going and to live until that case is resolved. And It is an existing non-party funding mechanism that still exists today. The second thing that developed in the late 1800s as the Industrial Revolution got started is liability insurance. What liability insurance is a non-party funder who's paid a premium and runs a business to make a profit, who agrees, among other things, that if there's a claim that's made that fits within the terms of that particular contractual policy, that they will pay the attorney and pay the funds for pursuing that claim. And everybody accepts that today, but the fact of the matter is in the 1880s when this got started, all of the issues that are being raised today about litigation funding were raised about liability insurance. And I don't have time to go through that, but I have a paper that does discuss it if you'd like to look at it. What does the insurance company do as a non-party funder? They pick the lawyer. They negotiate the fee with the lawyer. They decide whether to settle the case or not settle the case in most cases. So that's a non-party who's earning a profit, trying to earn a profit by selling somebody something to fund their case. More recently now, we have the development of what we are now describing as, quote, third-party funding, which is just another form of non-party funding, which is, I've been involved in it for about 20 years, and it's got various forms. One of them is specialty finance companies that focus their attention on specifically how to underwrite and evaluate the cases of a law firm in order to qualify them for funding. And many, many contingency fee law firms and other law firms go to banks, but more oftenly now they can't go to banks because banks don't want to fund law firms for various reasons I don't have time to discuss. And they go to these specialty funders. And the specialty funders are the ones that give the money to the contingency fee lawyers now so they can afford to take the case on a contingency fee. And those are law firm lenders and they get interest. The other thing is there's now a whole set, which we're involved in as well, for post-judgment funding, where somebody files a lawsuit, they win the case, and the other side now appeals it. Now they've waited for 3 or 4 years, and they've got another 1 or 2 years before they have a money judgment. Nobody's going to write them a check until the case is over. And one of the things that the post-judgment funders do is they come and say, okay, I'll buy part of that judgment. I'll take a ride with you. And if you win, I get a certain amount of money. If you lose, you get to keep the money, and I'm basically aligned with you. There's another group that funds settled cases where class action lawyers spend years and years and years not getting paid, pursuing cases. They settle the case, and now there's another 2 years, 3 years before they get paid. And there's another group of funders that come in and say, okay, I'll give you money now to keep you going while you're waiting for this settlement payment to be paid to you many years. And finally, which what I won't go into in a great deal today, because that's what a lot of the discussion is going to be about, is those who are putting money up to pay attorneys' fees, typically hourly rate attorneys, to fund a piece of civil litigation where on the other side you have a deep pocket defendant or an insurance company that's paying the defense fees and costs. And it's a wonderful burgeoning area, and it's growing, and some of you think it's controversial. I don't think it's controversial, because if you don't have that, then you're not going to have access to the system. And I'm looking forward to the discussion today. Thank you very much.
Thank you, Alan. Great. Thank you, Alan. That was terrific. We now have Lee Drucker, who will talk to us about evaluating the claim. What do you do as a funder to evaluate it? What do you do as a company that may evaluate it as well, but in a different way than the funder? And one of the key things here, and you should remember it forever, is that you're evaluating an asset. This is an alternative asset that is just like the chairs you're sitting on, just like a piece of art that's hanging on the wall. You can evaluate it. You can evaluate a share of stock. And once you can evaluate it, you can do all sorts of things with it, such as derivatives, as Tim said. So just if there's one key, how do you treat it? It's as an asset, and Lee will tell you about the evaluations of it.
Hi, everyone. I'm Lee Drucker. I am one of the co-founders of Lake Willens. Today I'm going to be summarizing my paper, A Financial Perspective on Commercial Litigation Finance. I really hope that this is the beginning of a conversation, so anyone that would like to email me, my email address is drucker@lakewillens.com, or if you want to have a public conversation, feel free to tweet me at Lee Drucker. So, what is a legal claim? From a financial perspective, a legal claim really isn't that different from any other financial instrument, like a bond. It entitles the claim holder to payment on its prescribed terms once it matures. However, unlike a bond, it's not clear whether the instrument will mature on its face. It first must be validated by the legal system. And this aspect of a legal claim causes it to bear substantial risk. Litigation finance enables the claim holder to redistribute this risk to a party that is most willing and able to bear and manage the risk. I intend to show that this redistribution of risk allows a company to allocate its resources to the highest and best use and optimizes economic growth. So let's imagine that you're the CFO of a venture-backed, high-growth company, and you're faced with the prospect of investing in a legal asset. How would you go about it? Let's assume that if you win, your returns will be $30 million. If you lose, nothing, and your likelihood of success is 70%. In this situation, the expected return would be $21 million. To estimate the cost, we want to know the budget, which is $5 million, the duration of the expected litigation, 3 years, and the hurdle rate of the project, which is 30%, which comes to an expected cost of $11 million. So what I have done right there is that's an opportunity cost. The CFO has the opportunity to either invest in his underlying business or in the litigation, but due to capital constraints, cannot invest in both. $11 million represents what the CFO would have earned had he invested in the company. So this is a no-brainer, right? On the one hand, you have an expected cost of $21 million, expected profit of $21 million, an expected cost of 11. There's an economic surplus to be had. But let's revisit the economic profile. Can we actually expect the CFO of a venture-backed company to divert the resources necessary to grow an $11 million profit into a litigation where there's a 30% chance of losing everything? This difficult decision is only compounded by the fact that the market and investors do not view proceeds from litigation as core operating profit. It's a one-off gain, and therefore will not be applied the same valuation as the rest of profits. So in this example, let's assume that the company is getting a 5x multiple on revenues. Now the situation is obvious. The CFO should definitively invest in the underlying business. A successful litigation only increases the value of the company by $30 million, whereas an investment in the underlying business increases the value by 55. Now let's introduce litigation finance. In this situation, imagine that a funder would be willing to cover the cost of the litigation in return for A, return of capital, and B, 1/3 of profits. Now, in the case of a successful litigation, the increased value to the company is $72 million. But even in the case of a loss, the company has accreted $55 million of value. This is because the CFO did not divert the resources to the litigation, but still maintains upside in the case. So obviously all the magic here is happening because somebody's willing to fund the entire litigation for only 1/3 of the profit. So let's take a look at why that happens. So this is kind of coming out a little awkward, but so in finance, risk is the likelihood that an investment will deviate from the expected return. The risk of holding a portfolio of claims is less than the risk of holding an individual claim. In the hypothetical, the CFO could invest the $5 million and had a 30% chance of returning zero and an expected return of $21 million. But if you could aggregate two of these identical claims into a portfolio, the chance of returning zero drops to 9%. If you could aggregate 10 of these claims, the chances of returning zero is virtually nothing. If you can aggregate 100 of these claims, the chances of returning anything less than an average return per investment of $17 million is about 1%. This is what the distribution looks like on a portfolio of 100 identical cases in the hypothetical. The high bar is the 21 million. So on the one hand, you have a single case where there's a chance of loss of 30%. And on the other hand, you have a portfolio of 100 where the chance of getting anything less than $17 million per investment is 1%. The risk of holding a portfolio of claims is much less than the risk of holding an individual claim. Investors must be compensated for risk. In this situation, the CFO is an investor. The litigation funder is an investor. What does this mean for the underlying asset of a legal claim? Well, if there's more risk, you must have more compensation. More compensation means that there's less value in the underlying asset. It's like a bond where the value and the yield are inversely related. So, the risk of holding a portfolio of claims is less than the risk of holding an individual claim. Therefore, the value of that legal claim in a portfolio is greater than it is being held individually. This is one of the reasons why the litigation funder is able to offer $5 million for only 1/3 of the profit when the CFO has difficulty making the $5 million investment for the entirety of the profit. The other reason is that litigation financiers' core business is funding litigation. So unlike the venture-backed CFO, when there are proceeds from this litigation, the value of the litigation funder's company increases. That's really the summary of my presentation. I think I'm pretty much out of time. So again, I'd really like to continue the dialogue, so feel free to email me or tweet me, and I look forward to talking with you guys more later today.
That's fascinating, Lee. And for your questions, keep in the back of your mind is his very persuasive presentation about risk right? Because the opponents of funding challenge that and say, you're asking for something like 3 to 5 to 1 on your return. That's way overpricing it for the risk you're taking, and therefore you're gouging the claimants by making a fortune. And is that challenge in any way valid? Is this really a risk, or is it just something that the funders like to say is a risk so they can charge exorbitant fees of 3, 4, 5, sometimes 10 and 14 times what the capital is they invest? Okay, now we have Radek. And Radek will talk to you, as I mentioned, about the sources of capital. There are many different sources that go into investing. It's not just from a funder, it could be from a bank and so on.
Hi everyone, my name is Radek Grau. I'm really delighted to be here. My thanks to Professor Zimroth and particularly to Dr. Linda Tvrde for putting this together and having me here. I'm delighted and really humbled to be a part of this panel. Those are some of the most experienced and knowledgeable people in the industry, so I hope to convince you that I have earned a place at that table, even if my star compared to those stars is a little star. So today I want to talk to you a little bit about various sources of money in litigation, and to do that I selected a really large and complex case, an antitrust case against a cartel of Asian manufacturers of LCD panels. By the way, some people in this room, including some people on this panel, know this case probably much better than I do, but still I hope to do a pretty good job summarizing it. I'm not going to go into detail about the case itself. What I need you to know about it for today's purposes is that the case got MDL'd, aggregating various kinds of actors, various kinds of claims and lawsuits together, and those actions then were developed and prosecuted in a sequence. So the main groups of claims were the criminal prosecutions by the DOJ, 2 class actions, a bunch of parens patriae suits by state attorneys general, and finally, commercial opt-out cases, individual cases filed mainly by corporate litigants. So the government went first, and it was like a ram that breached the cartel's defenses for everyone else that followed later. The DOJ obviously was funded by, with public money, but the point I want to make here is that that money and the results that the DOJ got on this case benefited private actors as well. To my mind, this is one example. If you consider litigation funding broadly, this is one example of public money funding private actions, at least to some extent. The second stage belongs to class plaintiffs, and their lawyers, they were contingency lawyers, two big classes, a huge class effort, 10 truckloads worth of documents during discovery, more than 300 years in attorney time, more than 18 million spent out of pocket. But the payout was pretty handsome as well. The lawyers between themselves took more than $500 million in attorney's fees at the end of the day. The class plaintiffs were funded by class lawyers, but the question is who funded class lawyers? And we don't really know, I don't really know, but there are some hints, and those hints come in the form of recorded transactions in secured credit. There are around 150 law firms involved in those two class actions. The IPP class, the consumer class, was more diverse and involved smaller firms on average. The DPP class was more concentrated, and so were their lawyers. Those were some of the largest plaintiff firms on the market, including Leaf Cabraser, for example. And what's interesting is that more than 60% of those smaller firms and almost 80% of the large plaintiff firms had at least some access to external debt secured by unearned attorney's fees. Now, how much of that third-party money got into this particular case, I don't know, but even if it was only a fraction of their lines of credit, those numbers, if you have 150 law firms, those numbers tend to add up. What's also interesting is that some of those firms were backed, although the majority were backed by banks, some were backed by non-bank alternative lenders such as LFG. And another interesting fact is that there's a clear pattern of long-term relationships between law firms and their bankers. Some law firms, including major plaintiff law firms, have relationships, secured credit relationships going 10, 20, or 30 years back. So they go 20 or 30 years without ever changing their banker. And I found that pretty interesting. Moving on, the third stage belonged to state attorneys general and parents' cases. They added numbers to the equation. Most of them, not all, but most of those cases made a part of large global settlement, so they worked hand in hand with class attorneys. And they were publicly funded as well, but I mentioned them because I think in contrast to the DOJ cases, this is also an example of public action prosecuted for public goals that benefited from the capital raised by private actors, or at least that exchanged some benefits with those private actors. And finally, the final stage, corporate opt-outs, corporate individual plaintiffs, they were the master piggybackers because they came last, and therefore they benefited from the effort and money poured into this litigation by everyone that came before them. And they were major players, and they hired major law firms, Big Law, AmLaw 100 listers. But what I found really interesting was that even among those big, powerful corporations, some found it useful to take advantage of third-party capital. Take a look at this group of opt-outs represented by the law firm of Crowell Mooring, sometimes with a co-counsel. And what turns out is that the two leading cases within this coalition, informal coalition, the AT&T and Motorola cases, were in fact backed by Juridica. It was an indirect funding through a very special law firm, but still, Juridica considers those cases a part of their antitrust portfolio. And the AT&T and Motorola cases were the trailblazers for the entire coalition of corporate opt-outs. They were filed first, they were used for interlocutory appeals, and they were also paving the way for settlements with individual defendants. So third-party money played a big role among corporate opt-outs as well. So what emerges here is what could be called a litigation waterfall, with money trickling down. In some settings, like in this LCD case, where there's a significant overlap in cost and effort required to bring those cases to successful conclusion, what occurs is this kind of waterfall situation, where the cases brought later are not only cheaper to prosecute, but they are also less risky, because much of that early stage uncertainty that is common to those cases gets removed and paid for by somebody else. So I want to leave you with two major points. One, money in litigation comes in various shapes and forms, but much of it is indirect and flies totally under the radar. It is never disclosed in the course of litigation. And two, there is this potential for the impact of third-party money being greater than the funded case itself, in that it tends to spill over to other cases that get collaterally funded. Great. Thanks.
Thank you, Radek. He is a good example, as is Lee, of the fact that we are now having coming into the industry youth that is going to carry this forward. I think both of these young men are good signs that, I mean, to write a thesis on funding, never would have heard of it a while ago. So this is really going on. One thing that you should be aware of, to me, the lawyers themselves are the key to so much of funding. The lawyers themselves, in terms of prosecuting the case, in terms of getting funding and so on, even though there are conflicts and problems. And right now, we are seeing some of the law firms actually getting funded in the UK by other businessmen who can, unlike the US, except Washington, D.C., who can invest in the law firm. So along comes Joe Business, invests in John's firm $100 million, and John uses $50 million of that to litigate. So there is a number of direct, that's the most, the strongest example, but there's also, for example, Burford has recently set aside 30 million euros for one law firm, Houseman, to prosecute competition cases, antitrust cases in Germany. So you're getting more and more into the lawyers themselves putting, that's not to mention the contingency lawyers, which of course invest their time in it. Now we have the Mr. Contingency Lawyer. John is, as I mentioned, a patent lawyer. He's a contingency lawyer, and he's also works with funding. So he's got a whole bunch of complications to tell us about. Where is, oh, there he is. Yeah, he's ahead of me as usual. Okay.
Good morning, everyone. So I have a little different perspective than the folks who came before me. I'm not a litigation funder. I'm a lawyer. So I think about these issues sort of the way as a lawyer does. My firm and my career mostly has been about half and half plaintiffs and defense, and my firm today is in that same place. I'm about half defense, half plaintiffs. So I hope I bring a balanced view. I've defended companies where the plaintiff was likely funded, and I represented plaintiffs who were in desperate need of funding. My practice, as Selvin said, is mainly intellectual property with a focus on high-stakes patent cases. The reason I'm exposed to this industry so much is patent cases are really susceptible to the need for funding, and there is a lot of availability of funding for patent cases. Patent cases, for those of you not in the industry, is very common to have double-digit million awards or triple-digit million awards. You read about them in the paper all the time, and it is not uncommon to have that. So the funders want to get into the space. Why do the plaintiffs want it or need it? Is because patent cases are hugely expensive. I was actually charmed to hear Mr. Zimmerman's view of what it costs, because in the patent space, it's not uncommon for the monthly fees to be $500,000 a month. The fees are, on the kind of cases I do, which are the high-stakes cases, regularly $10 to $15 million just in fees. That's over a couple years, probably over three years. So you're spending about $5 million a year in just the fees. The out-of-pocket costs are likewise in the single-digit millions. By the time the case is done, you might spend $5 million in costs. So if you are a plaintiff, oftentimes in the patent space, we get solo inventors, ladies and gentlemen who have come up with ideas. They file for a patent, and they think Microsoft is using it or Google's using it. And they don't have the wherewithal to put up $10 million so that they could go after Microsoft. So, they either need a contingency fee lawyer or a funder if that claim is ever going to see the light of day. And that's why I've sort of stumbled upon this industry in my practice. The thing that I learned over the years, too, is there are all kinds of funders, and this may be surprising to those of you who are not in this industry, but private equity, traditional private equity companies fund patent cases. I've worked with a couple, Altitude Capital, Arena Capital. These are traditional private equity funds, and they have the traditional structure for economics. Hedge funds fund patent cases. I've worked with Fortress and other huge billion-dollar hedge funds who have funded patent cases. Banks fund patent cases. Credit Suisse had a whole division that was dedicated to finding patent cases to fund. And they met with us several times when I was a partner at Kirkland & Ellis, asking to fund the cases that we took for plaintiffs. So these litigation funders that you heard about today and that we're going to hear about the rest of the day are actually relatively new to the space, because private equity and hedge funds and banks have been doing this for years. Now, what is the role for these guys if there are contingency fee lawyers like me? So my firm does, as I said, about half defense, half plaintiff. On the plaintiff side, we regularly take the cases on contingent fee. Why do we need funders if contingency fee lawyers will take the cases? Number one, because the cases are, as I said, could be running up $10 million in fees, and that's tough for law firms to swallow sometimes. But then there's this whole second class in patent cases where the expenses, the out-of-pockets, like the payment for depositions and trials, runs into the millions itself. Somebody's got to take that money out of their pocket. Secondly, sometimes plaintiffs, especially you can imagine a solo inventor, needs money to live if they don't have enough, and a funder will come in and give them money to live. Law firms generally don't do that sort of thing. But lastly, there's this other unique thing that has been presented to me a few times by different entities, where if the firm has a basket of contingency fee cases, funders have presented to me, I've never done it, but they've presented to me, how about if we come and give your law firm, $10 million or $20 million, and you go out and get more contingency fee cases. You'll feel more comfortable getting more if we're giving you money, and then we'll take a return on the basket of cases. So they're not betting on one case, they're betting on the bundle. So it's an interesting model. I don't know if any firms have ever done it, but it's been presented to me a couple times. We've never done it. But what I want to focus on now for the remaining minutes is, though, from a lawyer's point of view, what is going on here, and what are the dangers? What are the questions that need to be answered, and where can the center help? Number one, are these funding relationships discoverable? Prior to going into a funding relationship, the funders do diligence. They examine the claim. They turn up interesting information about the claim. Are those diligence documents discoverable? Are they protected by the attorney-client privilege? There's no real study about this in the law that I've seen, And the funders are adverse to the party they're going to fund during that diligence phase. So while they have a community of interest after they agree to fund, when they're creating the diligence documents, they're actual adversaries. So it'll be interesting to see if that stuff starts seeing the light of day in courts. And if some of those diligence documents are good for the claim or bad for the claim, it could be relevant to the litigation. Secondly, who selects the law firm? If a law firm has a regular relationship with a funding company, is the law firm going to be more loyal to the funding company than they are to the client that they're taking the case of when they know that their future business is actually coming from the funding company, and what are the ethical implications of that? Who controls the litigation is critically important. So if you're a law firm and you're representing a plaintiff, but you're being funded by a Selvins firm, who is calling the shots? Is the client really calling the shots on the client's own claim? And what are the agreements, the funding agreements say about that? And that boils into the next sort of who's controlling whether to settle or not. And these funding relationships gets very complicated. So a lot of in a contingent relationship, the normal relationship is a split of the outcome. So the law firm might get 35 to 40%, the plaintiff gets the rest, and everyone's aligned the whole way through because you only share in the pot of gold at the end. The way the funding relationships, the ones I've seen, they don't set them up that way. They take what are called first dollars. So if they give you 10 million, they get the first 10 million that comes from the award. Plaintiff gets nothing. More importantly, they need a return on their investment. So they actually get the first 20 million or 30 million. If you're, depending on your terms, you could have an agreement where that you have to pay 2 times what the investment was or 3 times what the investment was. That comes out of first dollars. So that changes the dynamic of the settlement in very important ways. So let me just give you an example. Assume you have a case with a potential judgment of $50 million. Assume the funder put in $5 million. Assume you're in the middle of the litigation and the defendant offers to settle for somewhere between 10 and 15 million, right? That 10 to 15 million pays the funder their full return. Twice the $5 million investment or 3 times the $5 million. They are really happy with an offer to settle of 10 to 15 million dollars. They're going to now pressure the plaintiff to settle, but the plaintiff gets nothing if they take a settlement of 10 to 15 million dollars. The claim is worth 50. So there are ethical implications here about the structure of the agreements. What does it mean to get first dollars? What does it mean to get 2x or 3x on first dollars? And what are the ramifications for the plaintiffs? Are the plaintiffs really in control of their case anymore, in control of their law firm anymore, and in control of the decision to settle? So these are tough questions that need to be answered from a legal point of view and an ethical point of view.
As usual, terrific. One thing that John mentioned, which is also below the radar in many situations, is what's the defendant's role here? The defendants, like the U.S. Chamber of Commerce represents the defendants, have criticized funding anywhere from being criminal to being evil, venom, and so on, because they don't like funding. And however, the defendants have a real, their lawyers should have a real interest in knowing about funding for 2 reasons. One is a simple reason, if a case is funded, it may have all sorts of different implications, such as what happens at settlement and so on. Defendants should know that and be able to determine what their strategy is going to be. So that's number one. Number two, funding is coming to the defendant's home territory. There are some funders who have funded some defendants who have been sued in one of these strike suits. And if it's a case that's a frivolous claim, why not fund the defendant in its defense? And why not couple that, perhaps, with insurance. So a funder goes in alongside an insurance company who might also insure the liability if it occurs. So the defendants are going to have a much greater opportunity in the funding, which I think is going to start to hit home. One also final comment about, John hit on very, very important things. Control. What is the conflict that might occur between the lawyers and the funder and the client? To me, the lawyers are in the trickiest position in any of these cases. That is the prosecuting lawyer, the lawyer that's getting paid. He puts or she puts themselves into a Bermuda Triangle. There is constant, inherent conflict between a lawyer and their own client if, in fact, they are choosing funding that might cost more but with a funder who sends them cases. Or otherwise, there is a division. Everything is not aligned in these interests, no matter what you hear, all these interests are aligned. They're different, and they're different at settlement. That's a very good example. So what is the lawyer's role here? Ethically, the lawyer has to look out for the client. Is he always or is she always doing it? Not necessarily. And that's going to come back to haunt them. The other thing is when they go out and a lawyer goes out to find funders, they don't know what the hell they're talking about. They don't know funding. Funding is a very complicated industry. And for a lawyer to think he or she knows how to find a funder, how to negotiate the best, they are fooling themselves, believe me. And therefore, what they're doing is they're putting themselves in the crosshairs of an ethical problem. They're incompetent to do what they're doing. What they're competent to do is to prepare a case for a funder or prepare a case for trial. They're incompetent, 95% of them, to go out and get funding. So they are, even just going into that arena, running the risks of ethical problems and also legal problems. They can be sued for malpractice. Lawyers don't even know this. That's how little is known about the industry so far, but it's becoming clearer and clearer, and lawyers are waking up to it. Well, that's enough for certainly from us. Now, I'd like to have questions or comments from everybody. Maybe we can start with anybody who has a burning question up here or comment, and then go out to, yes. Is that Maya? Maya, just to give her an introduction, she's on a panel a little later. Maya used to work for me at Latham & Watkins. She has since blossomed into the academic force in the funding industry. She teaches it, she participates in conferences and so on. So I dread it when she wants to ask a question.
The question is why banks are staying out of this space. I'm not a banker, but I can give you my explanation. Law firms are unstable economic businesses today. It's a fact. Why? Because the assets of a law firm, I call them elevator assets, which means that the lawyer gets in the elevator every day and goes to work, and if the lawyer doesn't get in the elevator every day and go to work, there's no asset. And a law firm is a bunch of lawyers who depend upon each other to show up and go to work. And what's happened, among the things that have happened, besides the economy and the impact of economic issues on, recession on law firms, is you have another industry that's developed in the last 20 years of legal recruiters and merger acquisition specialists, and they have an annual ritual of getting on the phone and calling lawyers and law firms and saying, hey, this greener pastures over at such and Smith, leave your law firm and go there. And you find then lawyers moving around from law firm to law firm. And you could just look at the list of major law firms that have been in existence for many, many, many years, centuries in fact, that in the last 10 or 15 years are gone. They're out of business. Dewey LaBeouf is the most recent, but I have in my paper a list of 10 of them. So if you're a banker and you're saying, well, what am I lending to here? You've got a 90-day receivable list, and you got work in process in the law firm, and that's about it. from a banker standpoint. They cannot evaluate. And you've got the personal assets of the partners who are willing to personal guarantee the loan. But they're not enthusiastic about lending to law firms. I can tell you that.
There's another complication too. So when I talked about Credit Suisse being in the business, they've disbanded the unit. And the reason they disbanded the unit was they were trying to fund individual cases, not law firms. And most of the defendants in the individual cases are big companies, and they're people.
Yeah.
So when the investment opportunity was fed up the chain to the management at Credit Suisse, they kept telling the group, no, we don't want that case because we'd rather give Microsoft a loan or rather do banking business with Microsoft rather than fund a litigation against Microsoft, as an example. So ultimately, the group kept referring cases and they kept getting rejected. So the group disbanded and all went actually to, they've dispersed to these funding companies now.
Or there's a risk that they might actually miss the conflict, and that's a very real risk that I actually realized in the past. And the bank ends up basically funding a case against either itself or its close affiliate, and that's not a good outcome for the bank.
That's exactly right, and that's why Credit Suisse went out of it. Allianz, the insurance company, did the same thing. It was very heavy into it, but then it found out there were too many conflicts, so it exited. I think that conflict is the biggest entry barrier. The other one is they're scared of their shadow. They don't know how to analyze and evaluate it. They don't know how to evaluate their own loans. So if you get them into risk, they run for the hills, and I think that's so. However, there are some, and here's my only comment, there are some that are trying to sneak into it. Deutsche Bank funded a case against Bank of America. Talk about conflicts. It finally came, and then you had the struggle that John's talking about. They wanted to find out in the court who was the funder. And needless to say, Deutsche Bank refused to tell them, all sorts of phony reasons. And finally, I think it was Judge Kaplan said, you tell me. And it came out it was Deutsche Bank against Bank of America. Bank of America went wild. So there is a very real conflict. There was another question over here. Yes?
The way the agreements are ordinarily set up, at least the ones I've seen, and I'm not a funder, so I haven't seen as many as these guys, but as the agreements that I've seen are set up is when the funding companies loan, the agreement requires that they get a return of either twice their money or 3 times their money from the first dollars from any settlement, and that's the way the terms are set up. So the plaintiff has agreed to that, but so I wasn't complaining about the economics of the agreement. What I was talking about is this notion that that money comes from first dollars, which then it creates the conflict because then when the settlement offer comes in, the funder wants to settle because they've got their 2x or 3x return. The plaintiff doesn't want to settle because they have nothing left. So it's in the agreement. They don't negotiate? Well, you're talking about individual plaintiffs who make bad deals, yes, but. So I'm not complaining about the terms of the deal. I'm complaining about the ethical implications of the deal, right? Not the economics of it.
But that's a really interesting question, right? Because even if you have a contract like that, usually the plaintiff retains the power to decide whether to settle or not. And the plaintiff has the power to spoil the game, basically to say, okay, if you get all the money, that I just won't settle, right? So that's the leverage of that sometimes is the thing.
There's a nuance to that too, because oftentimes the agreements, because the funders are not stupid people, oftentimes the agreements will have financial consequences to the plaintiff if the plaintiff rejects a settlement offer supported by the funder. So the agreement will say something like, if during the course of the negotiations, we recommend to you that you take a settlement and you refuse, that's your choice because you're in control of the settlement, but you will have the following financial consequences of doing that. It could be you're now responsible for some of our return, or it could be we're not going to continue to fund. It could, anything like that. And so it puts the onus on the plaintiff. It puts them in a difficult situation of saying, I better take the deal or I'm going to have some financial risk myself.
I think it's true, though, excuse me, Lee, that you don't come away from this thinking that there is one form of funding agreement out there, because they're not. I might say years ago, 5, 6 years ago, there were a couple of models floating around that people used, but with competition, and this is one of the paradoxes, with competition comes more responsiveness to client needs and genuine negotiation. So you could say, there are benefits to competition that alleviate some of these compressions at the low end of recovery that John was talking about.
That's a
Good point. We have a question here. Yes. You're 100% right. And that's a fear that every lawyer who's representing a claimant should have, that they're going to screw up things for their client because they don't know how to best protect their client, either in the financing. You heard a couple of comments now that won't come to the mind of an innocent lawyer. So what do? You can do two things, in my view. If you're in a firm, you have that firm set aside a small group, 2 or 3, that learn about funding, learn about funders, and protect that firm or any lawyer who's going into the funder. In fact, some law firms are becoming, quote, funder friendly. They're trying to attract cases, and to do so, they've got to become more active. The other thing is get an expert. Get an outside independent expert. I'm not sure a lawyer is the best one. Maya is an example. You can go to her, and she can give you expert advice. Yes, back there. Oh, I'm sorry, Alan.
I just thank you. I think that's a very important point. And one of our business practices is when we are funding a client to pay the lawyer, we require that the client go to another lawyer to get advice for that very reason, because it puts the lawyer who's getting the money in a tough spot, obviously, you've pointed out. But also, the last thing a funder wants to have is A, an unhappy customer, and B, somebody coming back and say, well, wait a minute, I didn't know what I was doing. So if you're giving somebody $1 million, you don't want, or $2 million, or $5, whatever the number is, you want to make sure you've got a binding contract and they know what they're doing. Secondly, I have a few other points. I'd like to respond. This issue about... I've done this. I've been doing this for a long time and thinking about it quite a bit, and we have our own practices. The issue of whether or not you interfere with a settlement is something that comes up and should come up when you underwrite a case to begin with. That's when you think about it. If this person or lawyer needs $1 million, is there a scenario where my $1 million or our company's $1 million is going to be such a significant amount that we're going to get in the way of settlement? And if so, we pass. We don't even do the transaction because we don't want to be in a situation where we are frustrating the settlement and we don't have any control over our agreements. We don't have any control over the settlement. So we want to make sure it's a rational decision because we do get paid first, and we don't want to interfere with that client deciding, yeah, I'm going to take this number. And so that's one way so you have to underwrite for that. Second, one other point, and I'll turn it over. I've got a lot of things I want to say, but I don't have time. This issue about discoverability is very, very critical. There is some case law on this. One is Miller versus Caterpillar, which is cited, and some other cases cited in this paper we did. But the best practice in what you do is you sign an NDA with the law firm so that the law firm, when they call you and tell you about their case, is covered by this confidentiality agreement that's binding. And you do the same thing with the client when the client comes on board. So everybody's subject to an NDA, first of all. Secondly, I'm frankly, personally, this is and I've debated this many, many times with a lot of trial lawyers. I'm fine with the other side knowing that our side has a lot of money You know, it promotes settlement. The first time I ever did a transaction was by accident, and the case settled in 3 months because the other side found out that the plaintiff had money. And so I don't know what's wrong with that. I don't know if they need to know all the details and the terms of the transaction, but if you sell to the defendant, hey, they tell you they got $10 million in coverage, and you say, yeah, we've got $3 million in money available to fight this case, let's sit down and try to settle the case, I think you're going to get a lot more settlements out of that. And that's my personal view, and there are a lot of people that disagree with me, so I'll leave it at that, okay?
There was a question, yes, way back there.
So going back to the issue of the question of what ethically, what are the new ethics challenges of litigation funding, and also based on the prior answer, it seems that most of this world is covered currently by traditional legal ethics rules and whatnot. But in terms of regulation of litigation finance as a distinct field, are we seeing the prospect of federal regulation, or are we going to see the prospect of a patchwork of different state regulations like that in insurance law? And also, is the prospect of regulation sort of now a Wild West with different agencies trying to assert jurisdiction and overlapping or even contradictory jurisdiction for what these funders can do?
On the first point about ethics, and then I'll pass it to these guys about the regulatory stuff, but on the first point of ethics, I'm not sure the current rules help in all instances because the funders are not lawyers. So if it's a transaction between a funder and a plaintiff, the traditional legal doctrines about lawyer ethics, I'm not sure are going to help.
That's true, John. However, it does help in controlling the lawyer, which lawyer has to be ethical. What you're seeing on the ethics front is that bar associations are coming out with ethics opinions specifically on this industry, because the general rules are very, very hard to manipulate. And New York, your home state, if you're from here, has what seems to me to be the best opinion on it. You should read it. It came out, I think, in 2012. Where's Tony? Tony was the first one to notice it, brought it to our attention, and it's a wonderful discussion of whether this is even ethical. According to Champerty rules, it says it's ethical. You may have misstated, but you can milk out of that you can actually control as a funder, which I think you should be able to do anyway, but that's a very hot topic. And the final thing is, it went through a bunch of ethical traps that a lawyer can fall into. So the best thing you can do is, in any state you're involved in, check the opinions that might have come out in it specifically. As to rules and regulations, yes, they're coming right down the pike. As you're sitting there, a Senate subcommittee is examining rules and regulations in this industry, because a lot of people have called it the Wild West and this and that. And therefore, there is rulemaking going on. It started in the UK. They're now revisiting it. They have voluntary codes. They're revisiting it for legislation. The US has it, and Hong Kong is in the process of enacting rules right now. So Peter, I think, said it's coming down there. It's coming. Yes.
Let me make a quick comment on that, though, Selvin, because I think it's pretty crucial thinking about regulation in this audience. There's a huge distinction between transactions with consumers and transactions between businesses.
Exactly.
Everything that I think we heard about this morning, at least from our two paper discussants, was about commercial transactions. Obviously, there's less need for regulation where Microsoft is transacting with Burford or what have you. There are regulations dealing with consumer-related finance in the litigation area. Probably not many dealing with law firm lending. But if you look at those three areas, and if you're wondering how they break out, there's a pretty seminal paper that the RAND Corporation did in 2006, 2007, that discussed these three areas.
Tim
think you're-
Ghost wrote it, by the way.
I think that what you're seeing is more regulation with respect to consumer activity could come out of the Consumer Finance Protection Bureau at the federal level, most likely at the state level. So that's kind of my view on it. Last thing about ethics, the key issue that lawyers face in dealing with third-party funding all comes back to a single basic principle, and that is independent professional judgment. That's what underpins the fee-splitting rules, say that lawyers can't split fees with a non-lawyer. It underpins other parts of the rules. But the key position is independent professional judgment. Can the lawyer withstand the contractual rights or the demands that might be made by a funder that would seek to interfere with his relationship with the client and his protection of the client? And that's the big issue. I mean, are lawyers powerful enough to exercise their duty of independent professional judgment to stand up to these kinds of things?
Tim, that's, as usual, is absolutely right. Let me make one point, related point. And, currently, every state has rules and regulations that we, as a funder, have to abide by. So you have 50 different states, even though there's a lot that are the same, there's different, and each one is independent. And then you have the federal, which is federal courts, but they're looking at the states. Now we might have federal regulations as well, and then you get into issues of preemption and so on. Okay, yes, we're almost at an end, so, no, go ahead. Oh, Boaz, how are you? Yes, yes. Uh-huh.
From my perspective, it's actually not a complicated issue. I think Tim did a nice job of setting. It does come down to independent judgment and also disclosure to your client. But I think that what you're seeing in the market, I think, is that law firms also, I think, one, the state of the industry has come to a place where we're very conscious of the ethical
Mm-hmm.
that lawyers have and have evolved agreements that are trying to work compatibly with them. And I think law firms themselves are having their own internal GCs dealing with these questions of independence. And so I think that, from my perspective, I don't think that any lawyer considering litigation funding should have concerns going into it. I think be mindful of them. They should understand the landscape in which they're working. But I don't think it's very complicated.
Thank you, Boaz. That's great. That's Lee's partner. Anything else that we have before we shut it down? Because it's time to shut it down. We're shutting it down. Thank you very much. Excellent question.